I'm Vinny Politan. Great to have you with us tonight here on Closing Arguments. And what a day in Minneapolis. Really an unusual day where no new jurors were added. We started the day with 9. We finished the day with 9. But there were some other issues that came up today, including a renewed attempt by the defense to bring in front of the jury during this trial the 2019 arrest of George Floyd. And there's body cam footage of it. We've shown it to you here on Court TV in the past when the defense first filed their motions relative to this evidence. And they want to bring it in. And what they're saying is that there is just so much of a similarity between what happened in 2019 and what happened in 2020, and it would help explain to this jury their version of what happened the day George Floyd died. So those arguments were made today. The defense laying them out. This is an enormous issue. I mean, enormous. If this video comes in, it changes a lot inside that courtroom, including some of the arguments the defense will be making and perhaps the way the jury sees the victim, George Floyd. That's why these arguments today were my biggest moment of the day.
Mr. Nelson, I'm going to ask you to approach the lectern and tell me why I should admit it and on what basis.
Thank you, Your Honor. We are advancing 4 bases. First, common plan or scheme, otherwise known as modus operandi, habit, intent, and absence of mistake. The entire arrest in May of 2019, just over a year prior to Mr. Floyd's death, is remarkably similar in multiple ways from one to the next, from the May 6th of 2019 to the May 25th of 2020 arrests. Beginning with literally the initial approach of officers and how the officers reacted to Mr. Floyd in that circumstance. In both of these cases, Mr. Floyd is in a vehicle. In one, it's a traffic stop, and the other, he's already parked. Officers approach, and the officers notice that Mr. Floyd begins acting furtively, hiding his hands. He's refusing to show his hands. Both officers in both incidents draw their weapons and escalate the use of authority or force in that regard. Mr. Floyd struggles, they struggle to get Mr. Floyd out of the car. Mr. Floyd immediately claims that he has previously been shot in both incidents. Mr. Floyd, again, struggles to get out of the car. He appears to resist their efforts to handcuff him. And he starts saying some of the exact same things that he says in this particular case, in the May 25th of 2020 incident, including calling out for his mama. He claims to have been shot, and he begins, this crying, kind of erratic behavior. Now, in the May 6th of 2019 incident, officers actually observe Mr. Floyd begin to put what they suspect are controlled substances in his mouth. And they threaten to tase him. They say, "Spit it out," repeatedly. Mr. Floyd refuses to comply, and he obviously takes these controlled substances. A search of the vehicle in the May 6th of 2019 incident reveals a large quantity of a variety of controlled substances. At the time of the original motion in this case, we had taken screenshots from the arrest in May of 2020 showing what we believed to be controlled substances in the mouth of Mr. Floyd at that time. The primary difference is that in the May 6th of 2019 incident, when they put Mr. Floyd into the squad car, he never makes a claim of claustrophobia. He gets into the squad car and he continues kind of the crying and erratic behavior in the squad car. As his body ingests or processes the controlled substances he took, you can see his demeanor change in the cameras, where he goes to an almost incoherent state while he is in the police station in the May of 2019 state, resulting in the police calling paramedics to the scene, and ultimately the hospitalization of Mr. Floyd. And there are the associated medical records from HCMC, or what was then known as HCMC, about Mr. Floyd's hospitalization. Those records indicate that on that particular day he took 7 or 8 pills prior to being arrested by the police. The paramedics in that instance, right, when they originally respond to the precinct in May of 2019, they specifically tell him, they're monitoring his vitals, and they tell him, you're at risk of having a heart attack or stroke. And his medical records also clearly demonstrate that he has a history of high blood pressure and hypertension. He had been prescribed medications for those. So you've got a person who is being specifically told this behavior, or presumably this behavior, is putting you at risk of having a heart attack or a stroke. So when we look at the exceptions to the general 404B exclusion, we look at common plan or scheme, right? Is this something that is so similar? Is this just that this is his modus operandi of when he gets arrested by the police? He, particular when he's in possession of controlled substances. So you look at this, and the similarities are incredible. I mean, it's the exact same behavior in 2 incidents, almost exactly 1 year apart.
I can't tell you how big of an issue this is and how this can change the trial incredibly if, in fact, that video comes in and the hospital records come in and everything else comes in. Let's bring in Court TV legal correspondent Julia Janae, who joins us tonight from Minneapolis. Julia, this is, to me, such a huge issue. How did the judge receive this argument? Because he's heard these arguments before. I mean, this is not the first time this has been an issue in the case, but it's a renewed attempt here. What did you take from the way the judge was listening to those arguments today?
In the beginning of those arguments, you could tell that he was falling back on what he's already done. He's already denied this as evidence coming in. Back in September of last year, he let the defendants know that this was not relevant. So today he initially said, look, I already have ruled on this. I found that it wasn't relevant and denied it. But you could see that the defense continued to make their arguments, and they talked about the new evidence that has come in from the May 2020 incident. The fact that George Floyd's car was examined again, and there was a locating of pills of fentanyl that were inside that vehicle, and that some of them were mixed with George Floyd's DNA. So the defense was using that as the reason for this renewed motion, and the judge did say that that was mind-boggling, that there was more information that had come out many, many months after this incident had happened. It was a second search of the car. So it seemed that he was receptive towards the end, more so than he was at the beginning, relying on his previous ruling in this case.
Let's put up on the screen and kind of break down the argument that's being made by the defense here as to the reasoning behind why it should come in from their perspective. They're saying that a common plan or scheme, his MO, habit, intent, absence of mistake. I look at all those arguments, and I've heard them made before in courtrooms, but usually it's the prosecution making those arguments to get in that type of evidence against the defendant. But here, it's the defense trying to get it against the victim in the case. That's what makes this a little bit different than what we normally hear.
Vinny, you've called this opposite world, and this is just another example of that. This is the victim who's not accused of anything. George Floyd is not the one who's on trial, so bringing in his prior bad acts to try to show that he acted the same way or that he didn't make a mistake or this was his habit, it doesn't seem at first blush to be relevant in any way. That's one of the reasons that this was denied initially. But the judge seemed to be most amenable to the argument of this helping understand or helping the jurors understand cause of death, where there's a question of whether or not this was an overdose or if this was the arrest. The defense saying that this goes to that cause of death as well, but the state saying that this shows that those officers in 2019 were able to subdue their suspect and not kill him, and were able to give him medical attention.
Yeah, let's take a listen to a little bit of the argument that was made by the prosecutor on this issue today.
He's offering it to show that, for example, the white spot in the video is not gum or spit. It is in fact a pill, which is proven by what is found in Squad 320, but also his common scheme or plan of when he's approached by police, he immediately ingests drugs. And that's also relevant because it shows acute intoxication, which might lead to the death. Or do I speak incorrectly?
That's correct, Your Honor.
Okay.
So if that's the basis, and not absence of mistake, blaming his hypertension, but let's assume that's the issue.
Well, I think the hypertension comes in with the whole point of ingesting drugs immediately before arrest leads to the state or the defense, part of the defense here is that they're saying it could have been a cause of death. And how do we know that it has a negative effect on his body is the May 2019 case where paramedic took blood pressure and his systolic blood pressure was over 200.
And let's not forget that in the May 2019 incident, the officers were concerned enough about his health that they sought medical attention for him. And they didn't force him someplace he didn't feel comfortable going immediately. They got him medical attention and he survived. I don't understand how those two things are similar.
So this is a fascinating issue. It's going to be a tough call for the judge. I mean, I think he's kind of leaning towards not putting it in, but it could come in. You know, a lot of times this type of evidence in cases like this would be, well, did the officers know this guy? It has nothing to do, have anything to do with the officers' behavior. The defense wants it to explain the behavior of George Floyd and ultimately the cause of death. They want to tie it all together there, which again makes it kind of unique in the way this type of evidence, they're attempting to use it.
There's also the question of intent. If we're looking at Derek Chauvin and his actions, will this video help them understand whether or not he did this intentionally, whether he knew there would be substantial bodily harm, whether or not he understood what he was doing to George Floyd? And this video, the state would argue, doesn't help add anything to that. Even if this was George Floyd not exhibiting true claustrophobia or anxiety during his arrest in 2020, the officers aren't aware of that when they are arresting him. And they told the judge that in a pretrial hearing. They all did not raise their hand when the judge asked them, were you aware of this prior arrest at the time that you encountered George Floyd? They were not.
Right. I mean, if they were, that's a major game changer. So the defense has sort of shifted the way they're attempting to use this type of evidence. But if this comes in, you know, for jurors to see George Floyd 1 year beforehand and then see him again, I think it puts everything that happened in 2020 in a slightly different perspective in terms of all of the interaction that precedes him being on the ground, which is when he's first approached, when they attempt to get him into the car versus getting him into the car. But in both instances, I mean, the prosecutor said they sought medical attention. I mean, they did call the EMTs, right? I mean, Chauvin and one of the officers there that day called the EMTs right away.
Right. After those senior officers, Derek Chauvin and Officer Tu Tao, showed up on the scene, they asked the rookie officers if they had escalated this to a code 3 that would have the ambulance come, and they said they had not. So that's when it was escalated, and they were aware that the ambulance was coming and did arrive many minutes later. All
right. Do we know when the judge will rule on this? Because again, I mean, they may, and if they lose, they may bring it up again, but when is he expected? Because this was the first time I saw the judge, as you pointed out, you know, looking at it just a little bit differently than in the past.
He did give that information. We've gotten some clarification on the exact timing that he plans to put out a written order that's expected to come on Thursday at 8:45 Central Time in the morning. He's going to let these parties know and likely put it on the docket so we'll be able to see it and let our viewers know what his decision is on this matter.
And again, this is a big one, folks. This is not a small little pretrial issue. No, this is a big one. I mean, it really changes a lot of things, especially the arguments that the defense will be making. And of course, seeing more of George Floyd for the jury also could change things as well.